Hi, so my name is Whitney Bellich. I'm an Assistant Attorney General, and I'm here with Lieutenant Eric Sweden with the Raleigh Police Department. He is a drug recognition expert and an instructor for the DRE program, as well as an instructor for standardized field sobriety testing. And Sarah Garner, who is the Traffic Safety Resource Prosecutor with the Conference of District Attorneys here in North Carolina. Thank you guys for being here.
Thanks for having us.
And we're here to talk about the cases involving horizontal gaze nystagmus, or the HGN test, that have come out in North Carolina in the past 6 months. So I wanted to start out by asking Lieutenant Sweden to talk to us a little bit about what HGN is.
So HGN, which is horizontal gaze nystagmus, is the first of the 3 standardized field sobriety tests. And it involves looking at the eyes as the eyes look at an object and they get moved to the side.
And what is that test intended to determine?
So the test is determined to find impairment, and that impairment could either be a drug impairment or it can be an alcohol impairment.
And do you see horizontal gaze nystagmus with both drugs and alcohol?
You can.
And officers that are trained in standardized field sobriety testing, are they trained in how to conduct the horizontal gaze nystagmus test?
They are. So the standardized field sobriety test battery is a standardized program nationally. So the first test is your horizontal gaze nystagmus, and the first things that they do is a medical rule out, and that is to determine whether or not the impairment that they're seeing is a medical impairment or if it's drugs or alcohol.
And how do they do the medical rule out portion?
So the medical rule out portion, you look at the pupils, you look for equal size of the pupils. So you want the left and the right eye to be the same size. If they're not the same size, you got some questions to ask to determine whether or not this is a medical condition that's occurring with the driver. Then you want to make sure that the eyes track equally. So do the left eye and the right eye follow your finger or your pen from side to side equally. And the last thing you want to do is look for resting nystagmus, which is when the eyes jerk when they look straight ahead.
And we've used the word nystagmus several times, but what does that word actually mean?
So nystagmus by itself is just the involuntary jerking of the eye. So the eye, when you look at somebody straight ahead, I'm looking at your eyes right now, they sit natural when I'm looking at you. When they jerk from side to side, that unnatural movement, that's the nystagmus that we're talking about. For the purpose of this test, the horizontal gaze nystagmus is when that eye involuntarily jerks as it moves to the side.
And so if an officer were to see something during this medical rule out portion, if they were to see unequal pupil size or a lack of equal tracking or something like, or resting nystagmus, what would an officer do if they saw that?
So there's questions we need to ask. So if the pupil sizes are unequal, well, that could be normal for some folks. So the question is really easy. Is this normal for you? And if it is, the officer will continue with the test. For the resting nystagmus, same thing. Ask, do you have this? Do you know this to be a condition that you have? And if they have it, well, you can't continue the test at that point, but at least you've noted the fact that you can't do the test because that resting nystagmus is present.
And so if you don't notice any problems during this first phase, or you determine that you are able to continue with the test based on training, what do officers check for after that?
So once the medical rule out is complete, they start the actual HGN test, looking for the indicators of impairment. There's 3 different tests that they're going to do. The first one is the lack of smooth pursuit, which is the inability of the eye to move even natural to the side. They're going to look for that. The second clue that they're going to look for is a distinct and sustained nystagmus at maximum deviation, which is when the eye is taken all the way out to the side. Does that eye jerk? And is it distinct? Is it noticeable? Is it sustained? Does it stay there? They're looking for that as the second clue. And the third clue is a onset of nystagmus prior to 45-degree angle, which sounds complicated, but it really isn't. It's that jerking of the eye before it gets to a certain point to the side.
And so, as a part of the training in conducting the horizontal gaze nystagmus test for officers, do officers conduct this test on people as a part of the training?
So they do. The tests are practiced on other folks in the class, usually other police officers, just so we can get the dynamics down. So you can get the timing, the distance, and you work all that out. The good part about the standardized field sobriety test program in North Carolina is we conduct alcohol workshops, which is when you bring in volunteers to get dosed with a certain level of alcohol, and then the SFST student candidates will do the horizontal gaze nystagmus on a person who is actually known to be impaired.
You've mentioned that these tests are standardized. Can you explain the importance of conducting the tests in a standardized way?
So every officer across the country who's trained in SFST is trained the same way. There are standardized tests, which are the horizontal gaze nystagmus, the walk and turn, and the one-leg stand. There are standardized administrative procedures, meaning the instructions for each of the tests are done by every officer the same way every time. And then there are standardized clues in each of the tests. So in the horizontal gaze nystagmus, there are 3 separate clues. And there's a standard arrest criteria, meaning if you see this number of clues, it would be indicative of impairment.
The horizontal gaze nystagmus test, is there science or scientific testing to back up the reliability of that test?
There's a lot. So when you go back into the 70s, some of the original research that was done, there are several papers, some of the latest studies, which aren't exactly new, done in the late 90s. All of this supports that, the standardized field sobriety tests, including HGN.
And are officers taught about those as a part of the training for standardized field sobriety tests?
They are. So there's a section of the standardized field sobriety test class that talks about how this happened. What did the original research say? What does the newer research say? And that is talked about that in class for every officer.
So Sarah, we've talked to Eric a little bit about what HGN is. Mm-hmm. Can you talk to us a little bit about these 2 cases that have come out recently regarding HGN testimony?
The North Carolina appellate courts decided a number of years ago that in order for an officer to testify about HGN, they have to be an expert. Now, expertise doesn't require a huge standard, but it means that you understand the science better than the average person does. So when the officers go through SFST training, they are taught about this, and that puts them in a position where they would have expertise. The rule that we have to follow in court is Rule 702 under the Rules of Evidence, and that deals specifically with experts. Rule 702 back in 2006 was an additional portion was added by the legislature that essentially says if an officer has been trained in horizontal gaze nystagmus and performs the test properly, then they are an expert in HGN. Now in 2011 they modified Rule 702, again the legislature did, to make us what's called a Daubert state, based on a U.S. Supreme Court decision relating to experts. When that happened, there was a lot of confusion as to whether or not that changed Part A1, dealing specifically with HGN testing. We finally have our answer. The North Carolina Supreme Court recently looked at the Godwin case again, and they reversed the Court of Appeals, and they said essentially that Rule 702, when it was modified, Part A1 did not change. And that the officer, if they are trained in HGN, and if they perform the test properly, then they should be declared an expert and allowed to testify as to their observations and the interpretation of those observations based on their training experience. Just last week, very recently, there was another case that came down and made it even more clear from the Court of Appeals, and that was the Yunt case. And the Yunt case specifically says, for all intents and purposes, when Rule 702 was amended, modified in 2011, that had no impact whatsoever on how we get our HGN evidence in front of a judge.
And so the difference between what officers would have to testify to get HGN evidence into court, how has that changed since before the Godwin and Yunt's case and after?
It is still important, even before and after, for an officer to be questioned in court about their training and their experience, and about the fact that they have been through SFST training, and about what they learned in SFST training. They also need to be able to be conversant, but maybe not completely knowledgeable chapter and verse in the testing that Lieutenant Sweden talked about.
Are you talking about the scientific testing?
Exactly. And the fact that it is a valid science. The officer needs to be able to testify as to how the test is performed, needs to be able to testify as to how they perform the test on the particular subject, and then interpret those results.
How do you think that these cases, if at all, are going to change how prosecutors ask questions about HGN?
I think it gives the prosecutors a better guideline. First off, there's no question now, they need to qualify the officer as an expert in HGN, not just ask them what test did you perform and what did you see. It's important for the officer testifying in the future, because once they have once they have been tendered and qualified as an expert in court, that's something that's beneficial to them in the future when they're testifying about HGN in the future. That the prosecutor still needs to ask the officer questions about, what were you taught about HGN? When did this start? How long has it been done? To show that it's not something the officer invented that day. The officer needs to do the test right, and he needs to do the test right every time. There's lots of times that the officer gets cross-examined about the results if an officer doesn't do it exactly right, if they don't hold the stimulus out for the specified number of times and what have you. And the officers need to be prepared to answer those questions as well, which is something Lieutenant Sweden could speak to better than I can.
Can you give us an idea, or give the officers that are going to be watching this an idea of what kind of questions they can expect from prosecutors to lay this foundation to get this evidence in?
Absolutely. The prosecutor's going to ask them about what sort of training they had. Officers tend to, in my experience, to kind of minimize their skills and abilities. And maybe it's just not being boastful. But when you're in court and you're asked about what training you've been through, I don't think a lot of officers even realize how trained they are and how much time they spend learning what they're doing. The other thing that they don't give themselves credit for is every time they perform the HGN test on a subject and then had their observations verified by a breath or blood test, then they essentially have performed independent study, and they have verified that this test is valid, good science, that it's the most reliable of the standardized field sobriety tests, because you can't practice at home. But the officer should be prepared to testify about, give some background and history of the test. They need to be prepared to testify about exactly how the test is administered, how many times they've administered the test, what their observations have been in the past, about going through wet lab trainings and things of that nature. They need to go ahead and lay it all out there, because every time you testify about HGN, you are teaching your audience, whether it's a judge or a jury, something that is completely foreign to them. It's got a funny name. That puts a lot of people off. So the officer needs to be able to feel comfortable testifying about HGN. And that comes from being familiar with their file, being familiar with the SFST training manual. And one of the best ways that they can learn how to testify about HGN is when they're sitting in the courtroom waiting for their case to be called, to watch how other officers do it.
Lieutenant Sweden, especially in light of these new cases, but also just generally, how do you train law enforcement officers to testify about HGN in a way that is accurate and in keeping with these new cases that we have?
There's a portion of the standardized field sobriety test program that has moot court, which is where you take an officer and you bring them up, and there's no way to train these officers really for court except to get up in that stand. But what the officers do need to understand is their role now is not an enforcement role, it's an educator role, to educate the judge on what HGN is, to educate the jury on what HGN is, to be able to explain what Sarah said is a complicated term, horizontal gaze nystagmus. You need to be able to convince a judge or a jury that just because you looked at somebody's eyes, you can determine whether or not there could be impairment there. So the timing, the administration of the test is going to be key. Did you do a medical rule out? Did you hold your stimulus 12 to 15 inches from somebody's face? With the implementation of in-car cameras and digital video and body cameras, the ability to take your enforcement and look at it over and over to make sure the timing is right. Did you go too fast looking for this clue? Did you go too slow looking for this clue? Those are the things that the officers are going to have to prepare for to make sure that their enforcement action is done correctly. But then can they explain it? Can they explain, like Sarah said, a little bit of the science behind? And if you took SFST 2 years ago, chances are good you're not going to remember which case we're talking about. So that preparation, that taking out that manual, that talking to an instructor who has taught hundreds or thousands of people, who's conducted wet labs on hundreds or thousands of folks, that's how they need to prepare. They need to talk to folks before they go in and try to explain this to a stranger, because horizontal gaze nystagmus, that term does not roll off the tongue.
If officers feel like they might need a refresher in this subject, are there options for them to brush up on the science and the standards behind the test?
Oh, absolutely. If there's an officer out there and they haven't taken a refresher in a couple of years, they're actually already behind just a little bit, because just a couple of years ago they added some of the newer research to the training, which wasn't available 4 or 5 years ago. They can seek out refreshers through their agency, through the local community colleges, through the Justice Academy, find out when a SFST refresher one-day class is being offered. They can look to their agency or in their region for a SFST instructor and just call and ask. Maybe sit down and have that conversation to prepare for a case. These are seemingly easy cases, but they're very complicated, and they're very complicated for the officer as well.
Sarah, just generally, and maybe in light of these new cases, what are some pitfalls that you can see for officers in testifying about HGN?
Well, lots of times in cross-examination, the defense attorney is going to hammer very hard on the standards under the Daubert case, again, which Rule 702 is based on. These latest cases out of the Court of Appeals in the North Carolina Supreme Court really take us away from having to follow all of the Daubert standards. One of the things they like to ask is, what is the margin of error with horizontal gaze nystagmus? And lots of times officers struggle with that question because there isn't a good firm answer. Officers need to realize there's nothing wrong with saying, I don't know. Saying I don't know is so much better than trying to come up with an answer. So they're going to question them on things like that. And again, the Young case makes it very clear that the officers need to be conversant. They need to know that perhaps that's an issue, but they don't have to have a firm, solid answer on it. They need to be familiar with the fact that a bunch of really smart people back in the day did a lot of testing on this and said, hey, we're not looking for something to help, but this is going to help based on our scientific brains. Lots of times the defense attorneys will ask the officers about the fact that they, as Lieutenant Sweeten was saying, moved the stimulus too fast, didn't hold it out long enough. And officers need to be aware of the fact, and they are trained, that if you don't do the test properly, the person who benefits is the defendant, because the HGN will be there, but the officer won't see it. They just need to be prepared to answer the questions as honestly as they can. The Yunt decision contains in it a transcript, a portion of the transcript, where the trooper who was being questioned answered cross-examination questions and did a wonderful job with it. Because there were several times he said, I can't answer that question because I do not know. I don't think the law requires them to know it, but they need to at least know it didn't just drop down out of space.
Anything about these cases going to prevent a defense attorney from asking those questions about the science in depth?
That would be entirely up to the judge. My reading of the case would say that going in depth into the science of it is not relevant. It's not relevant because the legislature has already said this is reliable science. The Daubert decision requires the first thing that the individual testifying be trained and have training experience, which can come through formal education or from on-the-job training or what have you. It requires that what they're testifying to be relevant to the issue at hand. And horizontal gaze nystagmus, or the lack thereof, is always going to be relevant on the issue of impairment. And the third thing that they've got to find is that it's reliable science. And that prong, the one that was causing the most difficulty for law enforcement officers and prosecutors, has been foreclosed, finally, by the Court of Appeals in the Young decision.
When it comes to testifying about what HGN means for impairment, are officers able to say a number based on the HGN test?
The studies on standardized field sobriety testing show that there is a correlation between an alcohol concentration and the onset of nystagmus or what the officer sees. But the appellate courts seem very uncomfortable with any sort of numerical value, either breath or blood test, attached to a person's impairment besides the use of the instrument or a forensic blood test. So the officers, out of an abundance of caution, and because, again, the Court of Appeals and the Supreme Court do not feel comfortable with numerical values, should testify as they are trained in SFST training that what they observe shows that it would be a good arrest decision. And of course, a point of weight or more is always going to be a good arrest decision. But since HGN is caused by certain categories of drugs other than alcohol, the point of weight is not as relevant.
Sarah, can you give us a little bit of a wrap up from what officers should take from these new cases and just HGN testimony generally?
Yeah. It's very intimidating to testify in any courtroom, and the best way to get over intimidation is preparation. Any officer that has to testify about HGN and has not done before can contact their local DA's office. Every DA's office has a copy of a DWI manual that was produced by a large group of people, and contained there is more or less a script to testify about HGN and the questions that you will be asked. Most prosecutors don't follow the script, but it gives it would give the officer something that they could sort of wrap their arms around to see what the tenor of the questions will be. And again, the best practice for an officer outside of a moot court training is to sit in the courtroom, pay attention to how other people testify, and see how to do it right, and sometimes see how to do it wrong.
Would it be a good idea for officers to talk to prosecutors in their district about what they can expect on the stand if they're not sure?
Absolutely. And sometimes the reason why that's good is because the officer needs to train the prosecutor about what to ask. Prosecutor's number one complaint about officers is they didn't answer the question right, and officer's number one complaint is that the prosecutor didn't ask the right question. And it's very important that they sit down, particularly before this first time. An officer can set the tone in front of a district court judge, particularly in smaller jurisdictions where you see the same judge all the time. Go ahead and set the tone. And if that judge thinks the first time the officer testifies about HGN that he knows his business, that officer's life is going to be so much easier down the road. And the judge will be educated as well about what a absolutely marvelous test this is for detecting impaired drivers and for not charging people with impaired driving that have actually got some sort of medical problem going on.
Well, thank you both for being here today. I hope that this was helpful to everybody with HGN. It is, like you guys said, a complicated test, but it sounds like maybe testimony has gotten a little bit clearer as far as what we can expect.
Thank you.
Thank you.